All rise. Board of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Alan Lawson, Judge presiding. All persons having business before the court draw near to the attention will be heard. God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning and welcome to an oral argument session at the 5th District Court of Appeal. As announced, I'm Alan Lawson. I'll be presiding today for the two cases we have set for oral argument. It's actually three, but one of the sets of cases is consolidated. The rest of the panel is on my right, Judge Brian Lambert, and on my left, Associate Judge John Woodard. Each case is a civil case, and each side will have 20 minutes. With the first case, there was no answer brief that was filed, so Mr. Skipper, you'll be the only one arguing. You can come on up and take your position. And then in the second case, I guess we'll treat that as two separate cases with 20 minutes per side. You may or may not need that. There are a lot of issues in those cases. So if you are the appellant, when it's your turn, if you let me know how much time you'd like to try to keep for rebuttal, I'll set the clock so that the light will turn yellow when you're into your rebuttal time. So first case is Eddie Williams versus Regina Williams. Mr. Skipper.
Good morning, may it please the court. My name is Mark Skipper. I represent Eddie Williams, who's the appellant in this case. This is an appeal off a final judgment of dissolution of marriage entered by the Circuit Court for Orange County. The parties were married, had a minor child as a short-term marriage. The parties were previously before the court on a domestic violence.
Let me ask you about your first issue. It's regarding a lack of findings, and in my review of the transcript, it looks like the trial court painstakingly went through each of the factors in 6113 and then orally, and then also said that in the final judgment that the best interest of the child had been considered as the overwhelming factor and along with each of the factors. And I'm wondering, under case law, that seems to be more than adequate.
Well, I believe the final judgment was just a regurgitation of what the testimony was, and what the father testified to this, the mother testified to this. This is what I believe, this is what we're going to do as far as the time-sharing plan.
Well, isn't that enough to support the finding that the court made that it was in the best interest?
I mean, I agree. It's an abuse of it's a discretionary test, and there's no indication as far as how they came up with this time-sharing plan. It was just, this is what Dad testified to, this is what Mom testified to. Here we go. I mean, there's no factual findings as far as this is why we're going to do it.
If you have recitations on the record in detail, such as you have here in the transcript, is not the finding of the best interest, is not that just a capstone, if you will, for what you've already recited on the record?
I mean, I understand what you're saying, but I don't believe there's an indication of how they came up with this. I mean, normally, if you go through the statutory factors, and there was no factor to say, okay, well, this factor is in favor of Mom, or this factor is in favor of Dad. It was just...
Does he have to make those findings? I mean, if a trial judge says, I've considered all these factors, I've listened to the evidence, and I find, based upon my consideration of the statutory, the subsections, that the best interest of the child is X, isn't that enough, assuming it's supported by competent evidence in the record?
I mean, I think there needs to be specific findings as far as each one, but I don't believe there are any. And I'm looking through the final judgment, and I don't believe there were any findings as far as why this is in the.
The trial judge ultimately agreed with your client that the child should be with each parent as much as possible, and has a time-sharing plan that seems very well thought out, that is not too far off from what your client asked for. I'm just...
Well, I believe that he gave the mother the majority of the of the weekends, and the husband would have four Sundays. Father has every other weekend, but father would have four
Consecutive
Sundays.
days each week, Wednesday afternoon to Sunday morning.
Right. Well, I mean, the father's initial, time sharing plan that he asked for, which is another point in my brief, court midway through the trial said, I don't think your plan is in the best interest of the child.
Well, how did the court's comments prejudice the case when the court went through in detail with its findings on the issue of the time-sharing schedule?
Well, I think that the father's time-sharing plan that he had proposed, right before he'd heard all the evidence, clearly stated that, look, I don't believe your plan is going to work, but I'm open to listening to other things. He'd already said, before he'd heard all the testimony, as opposed to just making a mental note or a mental impression that, hey, I don't think it's, going to work.
And a time-sharing plan, even though you try to be liberal with both parties, giving them what they may, didn't it appear that the way that the husband's proposal was, that it left room for too much change? I mean, you had different rotating times over a period of weeks where the parents would have to change maybe long-term schedules, the child would have schedules that would change, things that would become important as the child took on more social events and school, as it's brought out, and life.
Right, and I understand what you're saying, Judge, and that's, his time-sharing plan may not have worked, over the long term, but for the court to come out and say, well, in the middle of the trial, before I heard all the evidence, that, look, I don't think your time-sharing plan is going to work, I don't think that's appropriate.
It was pretty complicated, wasn't it?
Yeah.
Yeah, I mean, yeah, you'd probably say, it was not the standard, it was not a standard every other weekend, one night during a week, or, every other week, one parent has one full week and the other parent has the other full week.
He didn't say at the start of the trial, so now we're not doing that. I mean, isn't it?
Oh, it was-
He's listening to the evidence and.
It was about halfway through, Your Honor. It was probably about halfway through. When he said that, I don't think it's going to work, but I'm going to listen.
How many days a week under your client's proposal was he getting visitation with the child?
Under my client's proposal, what he had asked for, I don't remember, to be completely honest.
How many days did he eventually get?
He ended up with,
Its detailed findings.
he ended up with 100 and, I believe it was 134 overnights, Your Honor. So it was about a third. 36%, I guess, is the, according to the guidelines worksheet. We had also raised the point of, as far as the trial court made no factual findings as far as the attorney's fees, and that the father did raise that in the motion for rehearing, that the court ordered him to pay a portion of the mother's attorney's fees.
Before you get it, let me ask you about, you raised an issue about the daycare and including the daycare as part of the child support calculations.
Yes.
Did that get resolved at the motion for rehearing, do you believe?
I don't believe so. The orders from the rehearings said daycare shall be split by the parties based on income, 57% father, 43% mother. So it still had him paying a portion of it, even though the child was not in daycare at the time, and even though the mother was not working, it still had him paying a portion of it when the child wasn't in daycare.
Well, there was testimony at that hearing about when the child had attended and had not attended daycare, and there were calculations based on the daycare costs that were not imposed, and the arrearage was reduced from like 9,700 something to about 3,000.
Right. I mean, the court did order, the ongoing.
I mean, you briefed it as if that hearing never happened and those adjustments were never made, and it looks like that was taken care of at that hearing. If it wasn't, we can't tell that from your brief because you really don't address what errors were made at that second hearing.
Well, I think that the child support without the daycare was the 175, then daycare to be split on the income, and so the parents would handle those expenses by themselves. I don't believe the child. to be completely honest, I don't remember if the child was in daycare at the rehearing or not. As far, the court also ordered the mother to have the dependency exemption. We believe that was error based on the fact that she was not working. The court didn't consider that as part of the child support guidelines. There's no indication that the court did consider that. There's no factual findings for that. But the court still gave her the whole dependency exemption, and I think that factors on into the child support, and the court could not have awarded her the dependency exemption when she wasn't working. The father was clearly the one who was working in the whole time.
When was what was the father making at the time that the court decided the exemption?
He was making, I want to say it was about $17.75 a month, I believe, according to the guidelines.
And how much was he paying?
Paying in what? In child support?
Yeah.
It was, I believe it was initially ordered, it was 500 and, I believe it was 500 something that was initially ordered.
And was there a primarily responsible parent for the child?
Well, the mother was the primary, well, according to the time-sharing schedule, if you use it, the mother was the person the child would be living with the majority of the time. But she wasn't employed, to give her, the father was employed, even though it was not making a whole lot more money than her. They imputed her at minimum wage 40 hours a week.
Does the Internal Revenue Code have guidance in this regard?
Well, I think the court can order the parent to execute the necessary paperwork for that, and normally the parent who the child resides with would be, the majority of the time, would be the one. But if they're not working, then I believe it's error for the court to award the dependency exemption to that parent when they're not working.
Doesn't the code address that one of the criterias is who is the primary responsible parent? The parent, to use a term I think the code used, that has primary custody.
Right. I mean, that may be one factor, but there's no factual findings in the order to support, okay, well, this is what.
You keep saying that he was employed. It wasn't a testimony that he was unemployed at the time of the hearing and had been for 3 months and was collecting unemployment?
Well, he was collecting unemployment, but I believe during the majority of the time that he was employed in the mortgage broker business, as my belief, that he was unemployed most of the time.
Most of the prior year, but I thought
Right.
the testimony was that he was unemployed at the time of the hearing and had been for...
Right, at the time of the trial, he had no income, but that and it was getting unemployment, but the previous 9 months or so that he was working and was employed.
What was the difference in having the exemption for the father, if it had been granted to him, versus not having it monetarily, given his level of income?
Well, I mean, it would kind of reduce his overall obligation. As far as it's a several $1,000s credit basically. So I believe it would have reduced his overall obligation. The court also awarded the mother attorney's fees. There was no factual findings. If you subtract the father's child support that he was ordered to pay, puts the parties at an equal income level. There's no factual findings raised in the order. It's just the trial court said, okay, I'm going to pick a magical number, basically, for this is what you're going to have to pay off of the attorney's fees, even though you have a very marginal ability to pay. And then once you subtract the child support that he is paying, then the parties would be at equal incomes. There's no findings as far as there's a reasonable hourly rate, reasonable number of hours spent, why that he had to pay that portion of the attorney's fees when it was when they were at the same levels of income.
I guess he realizes this could be one of those situations where you need to appreciate what you're asking for. I think you're correct that there weren't there wasn't the testimony generally required under Roe regarding the reasonableness of the hours expended and the hourly rate, but the attorney for the wife said, gave the number of how much he had billed her, which, normally they can come in with that, and the amount awarded was significantly less than that, less than a third of that. So if we send it back for those findings, I mean, he could end up with a larger attorney's fee.
Well, I think also that the part, he didn't have the ability to pay. I mean, once you subtract the child support, if you look at their incomes, subtract the child support, which I think the court is obligated to do to consider the overall ability to pay, they're at an equal incomes, and he was pro se at the time. The wife clearly had the funds to hire counsel. He didn't have the funds to go hire somebody. I think he did not have the ability to pay. So even if it's reversed for findings, there's no evidence that he had the ability to even pay those fees. The court ordered it to be taken out, I think as $25 a month via an income withholding order. If you take out the court initially ordered it to be, I think it was $500 in child support. That dropped him down to the same income level as she was at.
Do we have any other questions?
I don't have any.
No.
All right. Thank you, Your Honors.
Thank you very much.
Thank you.
Thank you.